here in the publication of February 2018. If I can take the court to page 3 about this guidance, the purpose of the guidance is given as explaining the eligibility and criteria for those applying for leave to remain under the Destitution Domestic Violence Concession, that is DDVC. It does not apply to those whose leave was given as partner of a refugee or recipient of humanitarian protection who was not settled at the time of the application. That sentence isn't consistent, in fact, with the decision in A.
Is not consistent?
No. And Secretary of State. And there's a statement to which I'll come in a moment of the relevant officer of the respondent, and who sets out the position that, in essence, the written policy isn't to be read literally, because the actual policy has evolved. And I'll come to that in a moment. But para 2 is that. Next, under Appendix FM, it's stated the concession only applies to applicants who have previously been granted leave to remain as the spouse, civil partner, and married a same-sex partner of any of the following: British citizen or settled person. And that, again, is not a correct account of the actual policy as outlined by the department via Mr. Wood, its officer. At the top there's a section about partners of HM Forces personnel, which is irrelevant to this case. And so moving to the next page, the instruction to caseworkers: you must reject an application for the concession from those whose partner, 3 bullet points. First one is not at the time of application a British citizen or settled in the UK, was not at the time when leave as a partner was first granted a British citizen or settled in the UK, and is not a serving member of HM Forces considered exempt from immigration control. So
that again is not.
No, yeah, precisely, Malad. Again, that doesn't.
Just so I know, being reassured, we're not dealing with a bit about the forces, but is that correct? It doesn't. Don't worry.
I'd have to put on the white sheet. I'm afraid
I'm just wondering how useful this document is.
I haven't worked through the provision about the forces.
This guidance the guidance is aimed at who?
The caseworkers who decide the applications. Malad. Finally, on page 5 of the guidance, under the heading eligibility, this page tells you the requirements which must be met for an applicant to qualify for temporary leave outside the rules under the DDVC. For the purposes of this guidance, the definitions are the same as those set out in domestic violence guidance. That would be definitions of domestic violence. So the next paragraph: those who meet the criteria are granted 3 months leave and they're allowed access to public funds. And only those eligible for leave under section DVILR of Appendix FM or paragraph 40 of Appendix Armed Forces are eligible. Now, DVILR has been amended in light of intervening litigation and jurisprudence and policy decisions. So the reference to DVILR invokes a wider set of individuals, including some individuals who've been defined in previous pages as being outside the concession, such as the spouses of refugees who have limited leave to remain. And then there's reference again to the rules. It's in fairness to the respondent notes in the policy it's open to migrants and other routes to apply for leave to remain in the UK on the basis of family life, under another immigration category, or on human rights grounds. And then it said the concession applies either to those who are first granted leave to enter or remain as a spouse, civil partner, or married or same-sex partner of a British citizen. And then it carries on to deal with the armed forces. Again, and then the requirement for there to be a claim that the relationship is broken down to need access to funds and intention to apply for indefinite leave. So that is the written policy.
May I just ask, could you help us the reference to domestic violence guidance?
Yes, the domestic
Do we have that?
Yes, the court does.
It's the next document. Is this the next document?
It is.
And is this...
And it's at tab 25.
So this is the latest version of the guidance?
Yes.
So it extends the concept, as it were, to domestic abuse. In other words, it's beyond... The concept of domestic abuse has been recognised to be far broader than merely physical violence.
Precisely.
It includes, for example, coercive control. That's all now covered, is it?
Yes.
Within this framework.
Yes,
Thank you.
That's adumbrated in the Victims of Domestic Violence and Abuse guidance. One important matter is that the Victims of Domestic Violence and Abuse guidance operates in parallel to the 2018 guidance on the concession. It doesn't replace the concession guidance, right, if I can put it that way. So the Secretary of State still applies the 2018 guidance, although it said it's not applied literally, because read literally it's not accurate.
Yes. So when it says the definitions are the same as those set out in the domestic violence guidance,
yes,
is this what that means? That the people who are entitled to protection are those who are victims of domestic abuse as defined in the guidance?
Yes, yes.
Thank you.
Now, if I can take the court briefly to the supplementary bundle, to the statement of Mr. Nick Wood, which is at page 265 of the supplementary bundle. That is tab 11 of the supplementary bundle. It's the witness statement of Nick Wood, who is Para 1, Senior Policy Advisor on Domestic Abuse Migration Policy in the Human Rights and Family Unit of the Home Office, who are responsible for the policy and guidance relating to applications made under the destitute, the DDVC, the policy, and the domestic violence provisions under the immigration rules, which would be DV-ILR. Mr. Wood deals with the development of the policy. If I can focus particularly on certain passages, on page 266, at para 4, he indicates that the Secretary of State, since around 1999, operated a concession, that is the domestic violence concession, which provided for an immediate grant of indefinite leave to remain to a victim of domestic violence with limited leave to remain as the spouse of a partner or person present and settled in the UK. And he sets out the rationale for that. There are 2 paragraphs in his statement which set out rationales, and this is the rationale for the policy as it stood then. The rationale for the domestic violence rule concession was that individuals who come to the UK as a spouse or dependent of a partner who's present and settled in the UK, so this is the policy as it stood, will have come to the UK in the knowledge that their UK-based partner already has a right to live permanently in the UK. it is reasonable for them to expect to have their future and their permanent home with a partner in the UK. So from the outset, they may well loosen or cut their ties with the country of origin, their country of origin. The domestic violence provisions concession means that someone who's come to the UK on this basis and who is the victim of domestic violence should not feel compelled to remain in the abusive relationship for the sake only of qualifying for indefinite leave. They should also not feel compelled to leave the UK when the reason for being here, to live permanently with their British or settled partner, falls away through no part of their own. And the statement then describes the development of policy and at paragraph 12, because there has been the decision in A and Secretary of State for the Home Department in Scotland, and there have been other changes of policy relating groups to the DDVC. At paragraph 12, Mr. Wood notes the DDVC policy now remains in place, allowing certain victims of domestic abuse to apply for the no access to public funds condition to be lifted to enable them to flee an abusive relationship and apply for indefinite leave. The scope has broadened in line with changes that have been made to who can apply for DV-ILR, but it remains available only for those who can apply for DV-ILR. If successful, the applicant is issued 3 months leave outside the rules. The terms are set out in the lawful guidance, and that's the guidance the court has seen. Mr. Wood notes amendments, so he notes an endorsement of the policy rationale that the Home Office has expressed in affidavits and various litigation. I'll come to that in dealing with the law, in dealing with the cases, and I shan't deal with the cases here because I mean to deal with them individually. And so I'll come, if I may, to an extremely important paragraph in the text, which is paragraph 23. So this is the current policy, and this was quoted by Mr. Justice Kerr as the rationale advanced by the Home Office. And it's common ground that that is the rationale for the policy. The rationale for the present policy is, as stated above, that those who have come to the UK as the spouse or partner of a person present and settled in the UK, or with refugee status or pre-settled status, have come to the UK in the reasonable expectation of being able to live permanently. They would have an expectation of permanent settlement, but for the breakdown in the relationship as a consequence of domestic abuse. But those who have come as the partner of a person on a temporary work or study visa have no such legitimate expectation. And it's critical to our case, certainly, and to the way the matter was dealt with by Mr. Justice Kerr below, that rationale essentially makes the measure of inclusion the phrase reasonable expectation of being able to live permanently, which is paraphrased or referred to by the phrase legitimate expectation. And in the A case, which is potentially the most important case in the background to this, what was held was that the rationale, as then expressed, but the rationale of reasonable expectation of being able to live permanently applied equally to those who were spouses of refugees with limited leave, were then expressly excluded from the policy. And so the rationale meant that refugee spouses, or spouses of refugees with limited leave, were being within the rationale, their exclusion from the benefits of the policy were inconsistent with Article 14 read with Article 8. And so that is almost precisely the basic submission for the appellant in this case, as regards the policy as it now stands. It is that in terms of the essential rationale, the reasonable expectation or legitimate expectation, we're equal to the groups, or at least one group in the assumption of the judge below. And that being so, we're logically entitled to the benefit of the policy, because the policy is self-sustaining and the rubric determines what is within it.
Well, Mr. Fripp, you would accept, would you, that there are some categories of persons who can properly be left outside this scheme?
Yeah.
So let me just test what you would and what you would not accept. Suppose somebody comes as the spouse or partner of someone who has leave to be here as a student.
No, out with DDVC.
Right.
And equally the temporary worker.
Yes.
So something that arises in the case, which was perhaps a good illustration, is that some forms of worker are designated as being on the path to settlement, and it's policy that that is a path to settlement. That was the case of Tier 2 general workers, whose status is now within a separate category of skilled worker. But at relevant times, it wasn't so of intercompany transfer workers, ICT workers. And I accept that someone who is the spouse of an ICT worker is out with the policy. And I also accept, Malad, that the position is an objective one, and it depends on the form of leave that person has, and the designation attached by the Secretary of State to the form of leave. It doesn't depend on the subjective intention or thoughts
So
of the...
what is the quality or feature of limited leave to remain, which brings with it a reasonable expectation of being able to live here permanently?
Malad, in a nutshell, it's limited leave to remain on a path leading to settlement. Some people have limited leave to remain which is not on the path leading to settlement. Students never become entitled to settlement as students. ICT workers never become entitled to settlement as ICT workers. And those paths are designated as not being paths to settlement. But at the relevant time, Tier 2 general workers were, and the parties proceeded on the understanding below that that was the status applicable to the case. I hope those responses assist.
They do.
If I can just come...
Sorry, were you about to leave the witness statement?
I wasn't about to leave the witness statement. I was about to come to a final passage which deals
Please
with the individual circumstances, which is at page 273.
Okay. Just before we do, are you going to come back to my judgment in F.A. Sudan?
Yes.
All right.
I'm going to deal with the cases sequentially.
That's fine. Like, I noticed that it's quoted at paragraph 25.
Yes.
But let's deal with it when you deal with the case law.
Yes.
All right. Where are you going next?
Paragraph 33, this doesn't go to the law, but I'll deal with it in the interest of saving time, if I may, rather than come back to it on the facts. So this is the respondent's responsible officer who's addressing in the short paragraph 33 the application of the DDVC policy in the current claim, and says the claimant in this case has had her application under the policy refused. The claimant was not eligible for indefinite leave to remain under the DV rule. Her husband was not present and settled in the UK, but had only limited leave as a skilled worker the route formerly known as Tier 2 under the points-based system, as she could not qualify under the DV rule, she is also unable to qualify for the DDV concession. Now, Malad, if it's accepted that her husband was an ICT transferee, then what Mr. Woods says in that paragraph is incorrect, and it's incorrect in a way that has a material effect on the case, because the spouse of an ICT worker can't benefit.
So can or cannot?
Cannot. The spouse of a
Well,
Tier
that's
2...
correct. Then that passage is correct.
Well, the passage...
That's what he's saying. She cannot.
The passage... She's described there as being married to someone who has limited leave to remain as a skilled worker, the route formerly known as Tier 2.
Yeah, no, I understand that may be factually incorrect. But if in truth he was an ICT case, the legal consequence that Mr. Wood is describing in that paragraph remains true, does it not?
It would be true a fortiori
Yes.
of an ICT person,
Exactly.
and it's not our case.
Exactly.
As I've indicated, that an ICT
Yeah.
transferee spouse would have the protection of the DDVC,
Yes.
because it's designated as a route
Yeah.
not leading to settlement.
Yeah. Now, can I ask you about something else in that paragraph? Do you accept that the analysis is that you're not only challenging the DDVC, you have to challenge the DV rule? And Mr. Justice Carr said that he would give you permission to challenge that because that had always been implicit in your challenge.
Yes.
Do you accept that analysis?
Yes, Malad.
Right.
And I also accept that he indicated he wouldn't give relief against DV-ILR or the rules as settled. Our position is that we applied for the DDVC. We applied for the DDVC. We say that because we fit the rationale of the DDVC, we're within the DDVC. And we also say that if we reach the point of being in DDVC, applying for DV-ILR, at that point it would cease to be premature for us to say it breaches Article 14 read with Article 8 to exclude us from DV-ILR.
Seems to me, subject to further argument, that the substance of what you are challenging, and indeed must challenge, is the DV rule. Because the DDVC concession is a very limited concession. It's not ILR or anything approaching ILR. It's simply temporary leave for 3 months with access in principle to public funds,
Yes.
which is a gateway which allows that person to use that temporary period of a few months to make a relevant application for ILR.
Yes.
And that you can only do under the DV rule.
Yes.
So do you accept that what you are in substance challenging is the DV rule?
I do.
Yeah.
I mean, I'm in substance challenging, as it were, the network
Yes.
of the concession and the rule.
Yeah.
Yes.
Right, thank you. Now, is there anything else in this witness statement you want?
Malad, there's nothing else on the statement,
Right, thank
and
you, Ron.
I shall deal with the cases individually.
Right.
The provision in the rules is in the core authorities at tab 9. And this is section E, DV-ILR of Appendix FM to the immigration rules, which is referred to in various places as DV-ILR for the name of the. So, DV-ILR, indefinite leave to remain, settlement as a victim of domestic violence. the requirements must be in the UK, must have made a valid, that's the subject of a recent decision, AM, to which I'll come in dealing with the case law. The applicant must have made a valid application for indefinite leave as a victim of domestic abuse. The applicant must not fall for refusal under any of the grounds in suitability, indefinite leave to remain, which are the general public interest grounds for exclusion. The applicant must meet all of the requirements of section EDV-ILR, eligibility. So those include, and it's the next chunk of text, the first grant of limited leave under the appendix FM, must have been as a partner of a British citizen, a person present and settled in the UK. So those two groups have always been, or those two spouse groups have always been within the concession. A person with refugee leave, that is the A and Secretary of State people.
Mm-hmm.
Or a person in the UK with limited leave under Appendix EU in accordance with paragraph Gen 1.3d. And so that is pre-settled status under the EU settlement scheme, a grant of limited leave under the Brexit provisions. And finally, or as a partner of a refugee granted under para 352A, and any subsequent grant of limited leave must have been granted as a partner or granted to enable access to public funds.
Yes.
And EDV-ILR 1.2b refers to leave outside the rules under the concession. And EDV-ILR 1.3, this doesn't enter into the contested parts of the present case. The applicant must provide evidence that during the relevant period, the applicant's relationship with the partner broke down permanently as a result of domestic abuse. My lord, I now come to the cases, if I may, concerning the DDVC, and I'll take them in chronological sequence, starting with A and the Secretary of State, which the court has at tab 2 of the core authorities. So that petitioner was a Ugandan national who was married to another Ugandan national who was a refugee who had limited leave to remain in Scotland, in the UK. She was denied access to the domestic violence provisions, in this case DV-ILR, rather than the concession, on the basis that her husband, from whom she had parted because of his domestic violence, had limited leave to remain as a refugee rather than indefinite leave to remain. Those are the essential facts of the case. There was an affidavit there of the responsible official setting out the rationale of the underlying policy. And in relation to my Lord Justice Singh's point about the nature of the challenge having to be necessarily to the whole scheme rather than just to the concession, which I accepted, it's significant that the expression of the rationale given here is the rationale of DV-ILR, that is of the whole scheme, not just of the concession. It's at paragraph 19 of the judgment.
Yes.
And I should have noted that the judgment, the opinion of the court in the Scottish term, was delivered by Lady Dorian.
Yes.
She notes, para 19, page 784 of the report, the affidavit in which the rationale for the policy is set out, notes what they do, and it adds, Malad, might I just ask the court to read the indented quotation?
Yes, of course.
Malad, the court will see strong similarities between that and what is described by Mr. Wood in his affidavit in the present case as, his statement of truth in the present case, as the rationale of the concession. And here, the terminology is applied to the whole scheme, DV-ILR being the central aspect of that scheme, and it's applied to DV-ILR. It's addressed to it in the terms in which the scheme then stood, as limited to those whose spouses are British citizens or persons who are settled. And the formula has been adopted, in essence, in light of the ultimate decision in A and Secretary of State. But what remains constant is the core question being whether it is reasonable for an individual to expect to have their future and their permanent home with the partner in the UK. So from the outset, they may well loosen or cut their ties with their country of origin. On the facts of this case, I mean, factually, the facts may not matter to the issue, but factually this is such a case where the appellant was a qualified teacher in India with a good job, came to the UK, retrained to qualify as a teacher in the UK, taking the PGCE and intermediate courses on the way to that, anticipating a future, because she had been assured by her husband that they were on the route to settlement. And so
Forgive me, it may not matter, as you say. What we're concerned with ultimately is the lawfulness of the policy. But on the individual facts of this case, because they may help to understand the rationale of the policy, why can't the appellant go back to India with her child?
The appellant is afraid to go back to India because of lack of provision for single mothers, fear of her husband, and possible revenge from him. Fear of the difficulties of supporting a child and avoiding family contact, and in particular contact with her husband.
On the facts, as your client's case, as I understand it, she says abused in India before she came here.
Yeah.
And that the perpetrators of the abuse were not just her husband, but also members of his family.
Yes. But the reason I say the facts may not matter is because for us, in my submission, that is, the key measure is reasonableness of expectation, based on the objective immigration status. Our core submission is that someone who has limited leave to remain but is on a path to settlement within Tier 2, the limited leave to remain plus the path to settlement brings them within the rationale of the scheme. And so exclusion from its benefits is contra Articles 8 and 14. That's the core of it for in the case we advance. The court will have seen what is said there about the affidavit. And I'll move on, if I may, to the material part of the decision. Which the court has at page 799 in the report.
Yes.
At paragraph 66, the aim of the measure is reflected. In that case, unlike the present one, there was statistical material before the court which indicated that 95% of refugees granted 5-year limited leave or granted ILR at the end of the 5-year period. In the instant case, there was no statistical material on any group, either on EU pre-settled people or on refugee spouses or on Tier 2 migrants. I mean, it is our case that what is central is limited leave to remain, but on the path to settlement. And that there can be limited leave to remain on the path to settlement.
That phrase, on the path to settlement,
Yes.
where does that come from? Is that your submission?
It's from the respondent. It's the respondent's, it was at relevant times the respondent's position that Tier 2 was a path to settlement, even though you didn't have indefinite leave from the start. That it was a path during which you had limited leave and you moved to indefinite leave, and you contrasted that with the students, the ICT migrants.
I'm sorry, I didn't make myself clear, Mr. Fripp. Will we see that somewhere, for example, in a policy document, that phrase being used?
Yes.
Don't take things out of order,
Yes.
please. But if you can at some point give us the reference.
Yes, I'll take it. I'll take it in order, if I may. So the matter is introduced at 66. The statistical material is at 68.
Are you going to take us through 66?
Yes, let me.
Whatever. I mean, I'm just. We're going on 68.
Well,
For my part, 66 seems to be fairly important in your
yes. Well,
the analysis.
may I ask the court to read 66?
I'm not sure this helps you, because what Lady Dorian appears to be doing is drawing a contrast between refugee status on the one hand, where the person is here out of necessity,
Yes.
and the situation of a worker or student who is here by choice. That may not be the right place now to draw the line, but that is where she's drawing the line.
Yes. And because of the case, given the nature of the case before the court, it wasn't necessary to consider whether the line was anywhere else. So you could assume, for those purposes, that all workers were in the position of ICT workers, for example, who are out with the scheme. But
Forgive me. I don't think that's what she's saying is the rationale. She's saying refugees are in a particular position because of the international law which governs refugees, that they're here out of necessity. Whereas a worker, even someone who is a permanent worker, arguably is here from choice.
She is doing so, Malad, but she's doing so having noted that the rationale, beginning at line 3, the rationale for doing so is that the former are likely to have a reasonable expectation of settlement in the UK, and thus to have cut or loosened. And that's the phrase that comes back.
Yes. The second part of the phrase is part of it is an important part of it. It's not just a reasonable expectation of settlement, but also and thus to have cut or loosened their ties with their country of origin in that expectation.
Yes.
Now, a refugee who's been declared a refugee has the ties have been severed.
Well,
Let's not get
let's
not get bogged down with whatever word I use.
Yes.
But isn't there a distinction there?
In my respectful submission, a refugee via Article 1A2 of the Refugee Convention is someone who has a well-founded fear of persecution in the reference country, which is a country of nationality, or if stateless, country of former habitual residence, by reason of well-founded fear of persecution for one of the 5 reasons listed in the convention. So, an individual may, in those circumstances, be more dependent on developing, as it were, a new relationship with a protecting country because of the absence of protection from the country of origin. But it's not necessary that that be the case for someone to be entertaining a reasonable expectation of settlement and thus to have cut or loosened their ties. So that may be so of refugees, that may be so of other people.
Are you going to take us to paragraph 80 of the judgment at some point, Mr. Fripp?
Paragraph 80.
80.
Yes, I certainly shall.
All right. Well then, let's wait and see.
So
We get there.
that
So we read 66. 67 is the one that has the 95% figure.
yes.
What else do you want to look at?
Well, considerable weight is given to the relative precarity of the situation of the refugee as regard. That's 68.
Yes.
And then it said at the end of 69, proceeding to settlement at the end of the 5-year period is very much the rule rather than the exception.
Yes.
These indicate that the position of a refugee is in no way to be equiparated with that of a student or worker. And that reproduces the passage the court referred me to a moment ago. And the spouse of a refugee corresponds much more closely to the spouse of a British citizen or person settled in the UK. And I accept that, but I've responded to the point from the bench. So what is rejected in the next 2 paragraphs is the conclusion of the court below that refugees could be agglomerated with workers and students.
Yep. Right.
It said at paragraph 73 that the protection from removal is an important consideration. The fact that the position of refugee may come under review may indeed introduce a degree of uncertainty compared to the secure position of a settled individual. But that is not by any means to say that his position must therefore be considered precarious. You know, we consider that insofar as the Lord Ordinary appears to have considered that the immigration status of the husband was precarious, he was in error. Now, Malad, precarious is a term that also occurs in relation to Article 8 and immigration and the Rupia decision. decided that for those purposes, precarious essentially meant not having indefinite leave to remain. And my submission...
was a case about Part 5A of the 2002 Act, wasn't it?
Yes,
So the phrase, the word precarious is used, and the court was interpreting
yes, in that context.
the word in that context.
Yes. And my respectful submission is that the interpretation doesn't transfer over to the domestic violence context from
But the judge here
Part
didn't
5A.
use the word precarious. The judge in our case, Mr. Justice Carr,
No.
didn't rely on that strand of reasoning, so do we really need to spend any time on it?
Well, Para 76 identifies the fact that there had been a change of policy. And the change of policy meant that refugees had formerly had indefinite leave, and then they had gone over to limited leave in 2005. And at 5 years, they would be subjected to review of the claims if ministers were satisfied that there had been a significant and non-temporary change in the conditions in the country. That's Para 77. And the guidance note recorded that leave would also be reviewed or curtailed where the refugee had brought himself within the cessation provisions, acquired status by fraud, or had committed a serious crime. That's Para 78. So Para 79, neither in the explanation given in that case for the 2005 changes, nor an argument before this court was any material or submission advanced to indicate that at the time of the 2005 changes, any consideration had been given to the effect on the spouses of refugees who might otherwise have been able to avail themselves of the domestic violence concession. And the judge considered that just hadn't been contemplated at the time. I come to paragraph 80, where the court says, this is not, in our view, a case in which a policy choice on the critical question has in fact been made with due consideration of the issues looked at in light of the government's policy, both in relation to refugees and domestic violence. In the absence of any such choice or consideration, or any reasonable basis on which a refugee could be equiparated to a worker or a student, or the reasonable expectations of their spouses being as limited as those of the spouses of students or workers, and having regard to the effect on the spouses of refugees, we cannot say that the difference in treatment is proportionate. The position of those such as the reclaimer, which is the appellant, has simply not been brought into consideration. The effect isn't an informed choice. We don't require to examine in depth the issue of the standard of review because we're satisfied, even on the application of the higher test of whether the justification is manifestly without foundation, that it must be found wanting. We fully agree that policy choices of government are deserving of significant respect. We would not demur from the application of such a test, and then as reference to the relevant authority. So that's the basis on which the appeal was allowed in A.
Yes.
In the inner house of the Court of Session. The next authority is a decision in the case called T. Tab 3 in the core authorities. And in T, that applicant was the partner of a refugee who had had limited leave to remain, and after the relevant application which fixed the date, the sponsor, the husband, had got indefinite leave. And so there was, in essence, the argument that a phrase in DVILR should be read as admitting that, notwithstanding the fact that indefinite leave had been achieved later, not at the relevant time. And that was rejected by the court, and it's not any part of our case. And so I don't propose to address it in any detail. the reason for bringing the court to this authority. One, it deals with the concession, and the concession is addressed by Lord Justice Moorbig at paragraph 2. And then I should note that at paragraph 9, it's noted that leading counsel, as she then was for the appellant, had drawn the attention of the court to the decision in A in Secretary of State, but she didn't feel able to rely on it, given the way in which the issues in the T case had developed.
Yes.
And so that's the T case.
And it's dead against you. It's dead against you, isn't it? Paragraph 11. When considering an application under the DDV concession for temporary relief, the Secretary of State must ask herself whether, as things stand, the applicant would on the face of it be able to meet the requirements of section DVILR. If it's clear that she would not, the Secretary of State is entitled to refuse relief.
Yes. Well, this I can only address by our core argument, which is about the rationale and the comparator.
Yeah, no, I understand that.
Yes. Yes, but it certainly that passage which the court has read reinforces the link between the concession and the policy. That is the need to see the concession not as freestanding, but in
Exactly.
line with the policy.
Right, now where do we go next?
There was an Article 8 and 14 decision in DN in Secretary of State, which related to family reunion, which you have at tab 4. But I'll move past that to Malad, the decision in FA Sudan,
Thank you.
which is at tab 5.
Yes.
Factually, the position in FA Sudan was that the appellant was a Sudanese national. She had married a British citizen. She later moved to the Netherlands on a Schengen visa. Her British citizen husband hadn't lived in the Netherlands and hadn't worked in the Netherlands, so hadn't, on the face of it, exercised treaty rights. But he had essentially kept her in the Netherlands. And then he brought her to the UK. She entered the UK on a Dutch residence card and remained in the UK until she sought relief on the basis that she'd suffered domestic violence from her husband. The appellant raised a substantial number of grounds, both below and on appeal. And I can focus on one which is designated as the fourth ground in the appeal, which was an attempt to benefit from the Article 8 and 14 argument in relation to
Is that paragraph 54?
it is, but if I can bring you, I've summarized the facts, I hope adequately. I'll just draw the court's attention briefly to paragraph 16 to your judgment, Malad, where the summary of the DDVC and the immigration rules by Mr. Justice Murray is given.
Yes.
And then at para 17 of your judgment, Malad, the background to the concession was described by Lord Justice Moorbig in the T case of para 2, and that's then quoted.
Yes.
And then it's important to note your para 18. It's important to note that the para 11, Lord Justice Moorbig said, in my view, when considering an application under the concession, the Secretary of State must ask herself whether, as things stand at the date of the application, the applicant would, on the face of it, be able to meet the requirements.
Well, this is the passage.
Which was exactly the passage Your Lordship
Yep.
put to me.
Right.
Now, in the trial court, it has been held that FA was out with the DDVC because there's no evidence she was in the UK as a dependent in any case. She'd entered on the Dutch document. She hadn't had a subsidiary status as spouse. She hadn't had leave to remain.
Yes.
And so she failed on numerous different heads in relation to entitlement to rely on DDVC.
Yes.
And then,
Is paragraph 45 relevant? Because that's where I said the critical question is whether any discrimination was objectively justified.
well, you're,
And then 46 and 48. Well, really 46 to 48. Indeed 49.
Well-
This is all important, isn't it?
it is, my lord, yes. Paragraph 45 refers to the point being raised in that case, that there was discrimination, indirect discrimination on the basis of gender. And here the question is direct discrimination on the basis of immigration status. And there isn't
Yeah.
a...
I know that's a
gender.
ground of appeal that you're going to come to, I know, to develop. But what I'm really trying to get at is that in paragraphs 45 to 50 of this judgment, I sought to explain that there are many ways in which the state can protect the victims of domestic violence. It's not just through this concession.
Yes.
So the mere fact that somebody is the victim of domestic violence doesn't mean
Yes.
they're entitled to the protection of this policy.
I of course accept that. It's always been our case that not every victim of domestic violence is entitled to the protection of the policy. If I could refer to paragraph 46 of the judgment, the fundamental starting point is, as the judge recognized, the rationale for the policy. And that rationale is looking back to the policy, the reasonable expectation of settlement.
No, I'm afraid that may be the consequence, but actually the way I expressed the rationale
Yes.
was that a person whose application for settlement in the UK is dependent on her spouse or partner should not feel compelled to stay in an abusive relationship for that reason.
Yes, and that's another part of the expression of the policy in the various recitations by the department or by officials. But in my respectful submission, it's a part of the substance, together with the reasonable expectation of settlement. So the reasonable expectation of settlement arises from the interest that Your Lordship noted beginning at the end of the first sentence in paragraph 46,
Right.
referring to the policy.
I see. All right. Okay. And then what did you want to show us in this judgment?
Well, so, my lad, we've dealt with 46 to 50. Let me bring the court to the sections dealing with ground 4, page 9, or page 20. Paragraph 54, and there is page number 9.
Yeah.
So under ground 4, Mr. De Mello complains that the judge was wrong to say the decision in A was distinguishable. It would have been preferable if the judge had explained his reasons for reaching the conclusion. But Your Lordship says, I'm in no doubt that his conclusion was indeed correct. There's no respect in which, it's part of our case to contest any of it. And what follows leads to paragraph 57, which is that the critical point of distinction from the present case is that the appellant in A did have limited leave to be in the UK as a result of her relationship with the sponsor. The present appellant does not have such limited leave. The appellant in A therefore fell within the rationale of the policy. The present appellant does not. And my lad, I don't attempt to, as it were, overread that as admitting everyone with limited leave.
No.
So I wanted to bring your lordships and ladyship to the resolution of ground 4. There is another decision, more recent, the decision of Mrs. Justice Leven in Crown on the application of AM,
Yeah.
tab 7.
Thank you.
So here, this was another domestic violence case, but here the claimant was a person who was the victim of a phenomenon called transnational marriage abandonment, where a UK
Stranded spouse.
exactly, my lad.
Yes.
So she was a stranded spouse, and the position was that being a stranded spouse, she was out with the domestic violence provisions because those required someone to be in the UK. But her case was that that represented a disproportionate breach of Articles 8 and 14 read together.
So she's in Pakistan,
Yes,
unable to return, and her husband is in this country with a
yes.
child.
And the Secretary of State's position is that the policy is under review, number 1, and that number 2, such cases as arise of transnational of stranded spouses can be dealt with by general discretionary powers without needing to include such cases within the benefits of...
Is the Secretary of State appealing this judgment? Do you know?
There's nothing on Westlaw to indicate any appeal. I don't know whether my learned friend is able to.
In due course, we can ask Mr. Anderson if he knows. Anyway, the first point you say is the policy is under review.
Yes.
What's next?
The first point for the Secretary of State is the policy is under review. The second point is we can deal with these cases sufficiently to mitigate adverse effects using general discretionary powers without people having to be within the domestic violence provisions. There was also an element of whether to deal with it when it was academic, because she'd been allowed to return to the UK with a discretionary grant of leave. But, here, Mrs. Justice Leven cites at para 22, page 738 in the report, the aim of the measure as set out by Lady Gorian in A and Uganda.
Yes.
It said the Secretary of State accepts that this is an accurate summary of the aims of the DVR provisions. And this expression in the indented quotation does include that phrase, reasonable expectation of settlement in the UK, to which we attach weight in our case. Moving on, there were 2 grounds. The first ground failed, and I don't need to deal with it. And it's nothing, it has no reflection in this case. Ground 2, this is page 746. Ms. Chapman submits that the failure to make provision in the immigration rules for victims of TMA is in breach of Article 14 read with Article 8. She says women who are the victims of spousal abandonment are given the protection of the DVILR if they're present in the UK when they're abandoned, but if they're tricked or persuaded by their abusive partners to travel to a third country, then they have no protection. She submits this as unlawful discrimination, lacking rational justification. There's reference to the SC framework. the reply for the Secretary of State, it's accepted that Article 8, the ambit of Article 8 applies. It's accepted that the difference is based on another status, in that case geographical location. And then moving to the next question, that's 64. The next question is whether AM, having been abandoned in Pakistan, is in an analogous or relatively similar situation to a spouse reliant on the spousal visa who's abandoned in the UK. This has to be considered together within the next two stages of the analysis. Whether the differential treatment has an objective and reasonable justification, and thus perceives a legitimate aim, and whether it's a proportionate means of achieving that aim. On the facts, the question of relevantly similar situation and justification covers the same ground, and that respectively reflects the way we put this case. We say it's the rubric that determines who's inside and who's outside, and that goes both to similarity or equivalence and to justification. It said the para 65, the defendant has not put forward any evidence as to her justification. She's reliant on Mr. Fletcher's submissions. And there is no witness evidence at the end of 65. She says, as I understand Mr. Fletcher's submissions, the justification for not making a rule is twofold. First, the defendant is reviewing the policy position, but simply has not reached a conclusion. It said that there's no time frame for that. Next, at para 69, Mr. Fletcher's second submission, the current situation allows the defendant to consider each case individually, on its own facts, through the process of leave outside the rules. Therefore, victims of TMA are not debarred from gaining entry to the UK, but simply have a different route. There's reference to witness evidence of how difficult it is to gain access to the alternative routes where you aren't plainly within a scheme. And the court indicates at 71, in my view, this is the unusual case where the defendant has failed to meet the requirements of Article 14. The comparator on which Ms. Chapman relies, or the person in an analogous situation, is the victim of spousal abandonment in the UK who can rely on the DVILR. Such a person will have suffered the same form of domestic abuse, the only difference being geographical location at the time of abandonment. The policy issues are the same. The difference, being presence or otherwise in the UK, leads directly to the broader issue of justification and whether failure to make rules raises a legitimate claim. And then the justifications are dealt with and are rejected. So as to in the issue, the judge says at 74, the next question is whether the failure to make relevant rules has a legitimate aim that is proportionate. There does not appear to be an aim in not making rules. It's simply that the defendant has not addressed her mind to the issue or has not yet formulated the proposed review. The defendant has a margin of appreciation. Indeed, in the case seeking the formulation of a rule, generally a wide margin. However, such a margin is not untrammeled where there's ongoing discriminatory treatment, particularly where there's serious domestic detrimental consequences to the victims. Here, para 75, the two justifications do not, in my view, stand up to scrutiny. The first is that the defendant needs more time for the review, but in essence, that isn't a good reason. The second is that cases can be dealt with outside the rules, but that's not a good reason because of the difficulties attached to the route.
But this is about a very different situation, isn't it?
Yes.
It is.
It's apples and pears.
In some respects, in some respects, it's a claim which is more ambitious than the appellant's, and it's more ambitious in that what seems to be being sought, or at least considered, by Mrs. Justice Leavin, is whether there's an obligation to make a rule by the Secretary of State. And what we say is not that the Secretary of State is obligated to make a rule, but what we say is that we're within the rationale, so our personal exclusion from the benefits of the policy represents a disproportionate breach of the two provisions of ECHR read together.
No, I only meant that it's distinguishable in the sense that at paragraph 71, the judge said that this was a person who, but for the fact of geographical location, can rely on the DVILR, whereas your client cannot. Now that may not matter at the end of the day, but I'm not sure how much we derive from this judgment, which helps us to answer the question we have to answer.
That may be so, my lad, but the distinction your lordship raises to me from the bench, or the difference your lordship raises to me from the bench, may be actually one of form. I mean, the Secretary of State's position would be that AM doesn't meet the requirements of the scheme, the concession or DVILR, because she's out with the UK.
Well, apart from the fact that she's out with the UK, she would seem to fall within the rationale as in Mr. Wood's statement.
And my respectful response to that is, she says we're out with because of the form of leave we have, but if we so in both cases she says the DVILR doesn't apply. It's absolutely correct, and I fully accept it's a different aspect of DVILR.
From my point, she was quite a long way from the fact of this case.
Well,
not least because the process of abandoning spouses abroad, stranding them abroad, is a form of domestic abuse.
yes, well,
in itself.
I accept that the facts are very different, but in each case there was a challenge mounted on the ground of Article 8 read with Article 14.
The facts are different, the challenge is different, and also the way that it was argued by the Secretary of State was very different.
Yes, well, I accept
the defence, the justification defence, all the
yes, and we
defence
had
were different from how it's argued here.
And on the judge's analysis, see paragraph 74, the difference in treatment that she thought had to be justified was the failure to make relevant rules.
Yeah.
Yes.
And I think that's how you have to understand what she says in paragraph 74.
Yes, my lady, and I think my brief point to that was that that's actually a stronger submission being made by Ms. Chapman than the submission we make for the appellant. I mean, we
Depends
say
on the facts, doesn't it?
we say our case is essentially an interpretation, essentially a policy interpretation case. We say we're within the rationale of the policy. And so to exclude us from the policy, contra the rationale, represents a disproportionate breach of Articles 8 and 14.
That's what this case is about.
Yeah.
Mr. Fripp, it's entirely a matter for you how you present your case, but I bear in mind what was agreed between counsel, what would be the time allocated for the appellant. And you've got about half an hour according to that timetable. Of course, we will give
Yes.
you longer if you need it, within reason.
Well,
But it just seems to me, as I say, it's a matter for you how you present your case, but what you may need to focus on is what the attack is on the policy in the present case,
yes.
and whether the judge was right or wrong at paragraphs 75 to 83 of his judgment.
Well, Milan, much of the law is common ground. That is, the test to be addressed is common ground,
Yes.
and is likely very well known to the court.
Indeed.
And so I'll move to the facts. I'll deal relatively quickly with the facts, and then I'll deal with the substance, I hope. And I'll seek to meet my time.
Well, I don't want you to feel under undue pressure.
Well, Malad, let me seek to meet my time.
All right.
Malad, there was a query from the bench
Let's hear it.
how one knows that Tier 2, as it stood, that Tier 2 general was a status that led to settlement. And my response to the question from the bench was that it's set out by the Secretary of State, and the place at which it's set out by the Secretary of State is at tab 31 of the additional authorities, page 15, which is the Secretary of State's policy.
You're going too fast for me now. What's the reference?
The reference is, well, this is the respondent's policy as it stood at the relevant.
What's the reference?
The
which
reference
volume?
is tab 31, authorities tab 31.
Thank you.
So this is the new bundle of authorities that we got this morning.
It is, my lady, yes.
Thank you.
And it's at page, the primary reference is page 15. If you care to look back to the start of the table is headed Tier 2, brackets, general, close brackets, key facts. And all I need to point to on page 15 of the policy is next to the question, does this category lead to settlement, indefinite leave to remain?
Yes.
Answer, yes.
Right. Thank you.
Also page 86 of the respondent's policy.
In the same tab.
In the same tab,
So which page?
page 86 of that.
I can't find that at the moment.
It's almost at the back. Not all the pages have been copied.
Mine ends at page 50.
I've got an 86.
Yes, I've got an 86.
Just before the... It's almost the last page in the...
Oh, sorry, I've got two documents in this. I'm not sure why. Page 86. I have that, yes.
It's
No,
headed Tier 2 General Minister of Religion and Sports.
Yes, no, I'm very sorry for any imperfection.
No, no,
It
don't
was
worry.
created
What do you want on this page?
Under Tier 2 General
Yes.
and other subcategories, settlement requirements. The essential text to note is the heading, requirements for indefinite leave to remain. And it said, you must grant ILR if the applicant meets the requirements of Para 2458 HF, none of the general grounds apply, and there's been 5 years in one of the relevant categories, and so on. So that reflects the fact that this is designated by the Secretary, was designated by the Secretary of State at the relevant time as leading to settlement. And then that is elucidated further at 86.
You say this in substance amounts to an acknowledgement by the Secretary of State that a person in this category is on the path to settlement.
Yes.
Not a phrase we see used in the policy you've shown us, but that's what you say it amounts to in substance. Is that right?
Well, what you've just seen is the Secretary of State's policy as
I know,
regards that class of
but
migrant.
do we see the phrase the path to settlement?
You don't see it in the DDVC, and essentially our case marries up.
No, do we see it in this document that you've just been showing us?
It is.
It may not matter. I'm just asking you whether that phrase actually appears in this document. That's all.
No,
all right.
the terminology there is leads to settlement.
Okay, that's
Does
fine.
it lead to settlement?
Right, but you say in substance that is the crucial point.
Yes.
Right.
Yes. Path to settlement is a synonymous usage.
Yeah. Okay. Right. Anything else in this document?
Nothing.
Right. Thank you.
So, my lad, let me move on then from the law. I mean, we fully accept. I've shown you those references in relation to Tier 2 general migrants. We accept that the equivalent references as regards a Tier 2 ICT migrant would go the other way. You know, so
That's
not
very fair.
not a path to settlement. On the facts of the case, the court will have seen the background in the replacement skeleton. Let me briefly take the court to the decision and the challenge, which is at the core bundle, tab 10, or page 115.
I mean, we have looked at all of this. I mean, it's really a matter for you, Mr. Fripp, whether you feel the court will need to see these.
Yes.
I'm not going to stop you if you want to show us something you think is important.
Well, I wanted to draw out points going to both the substantive case and the issue of the immigration status of the husband, but I can perhaps do it more shortly than by taking you to each individual document. In the respondent's decision of 6th of August 2021, page 115, it was said that the husband was last granted leave as a Tier 2 dependent. So that's an open phrase. It could, we accept, mean Tier 2 general or Tier 2 ICT, but we hadn't taken it as meaning Tier 2 ICT. And there would have been considerable sense in saying Tier 2 ICT, if that was what the respondent meant to say. In the letter before claim done by those instructing me, the husband's status was described as being a Tier 2 dependent visa, and that reflected the way it had been put by the respondent in the decision. And because it's been throughout the case that the appellant, she left the house with the escort of officials when she sought to escape by reason of the domestic violence.
I think this is accepted by
Yeah.
Mr. Anderson.
It is.
That's why he's applying to adduce new evidence before this court. He
Yes.
accepts, I think,
Yes,
the way in which the case proceeded below was exactly as you have told us.
yes. Until after the respondent's notice,
So-
when the respondent's skeleton.
Indeed.
raises
Well, it may,
its first line.
as I say, it's a matter for you, Mr. Fripp, but it may be a more economical use of the time you've got to open your appeal. If you respond to any points that Mr. Anderson wants to make when he makes his application to
Yes.
adduce new evidence.
Yes. Well, let me leave the facts, if I may, move to the first section of my submissions. And so, as to the respondent's application to adduce further evidence.
Sorry, I thought you were going to deal with that when you respond to Mr. Anderson.
Well, I can do so.
You've got on your timetable, you've got about 20 minutes
Yes.
now. And I, speaking for myself, I think what would be most helpful is if you advance your positive grounds of appeal as to why you say Mr. Justice Carr was wrong at paragraphs 75 to 83 of his judgment. Because that's your appeal.
Yes, and I'm very, very content, allowed to do so. The on the well, the issue of justification is, as your lordship has noted, dealt with by Mr. Justice Carr, beginning at paragraph 75. He says the government must explain not just why it brought in the scheme, but why it did so in a manner that discriminates against the SWP cohort by treating them differently. That's then taken as being Tier 2 migrant spouses from the partners of pre-settled EEA nationals. I accept that the spouse or partner of a Tier 2 worker in the position of SWP may face a difficult choice between returning to an abusive relationship or leaving the UK, but I've concluded without difficulty that the difference in treatment is justified for the following brief reasons. First, the cases don't assist Gegosuz and Ponomariov. They're both star cases of direct discrimination. Now, we do accept that the facts are very different in those cases. But it's certainly our case that here there is direct discrimination. There's direct discrimination because on the basis of the relevant characteristic, the appellant is excluded from the benefit of the policy. You know, there would be indirect discrimination if there was some other policy action which indirectly excluded her. But we say we're within it. This is essentially about the interpretation.
Yeah, I understand that point.
Yes.
I understand that point. But what Mr. Justice Carr went on to say was that in both cases the discrimination was based on nationality. And I think that Mr. Anderson submits that that's the crucial distinction from cases like Gegisus and Ponomaryov, whereas you haven't got here discrimination on grounds of nationality. You have got discrimination on grounds of immigration status.
Yeah, and I accept that nationality is one of the strong bases, according to the cases.
Yeah.
And I accept that immigration status isn't. Immigration status is a basis, but it's not specifically identified as a strong basis.
You say strong. In the terminology used in the case law, there's often use of the word suspect ground.
Yes.
Is that what you're
Yes,
submitting?
Suspect, strong.
Yeah.
You say this is a case of direct discrimination.
Yes, we do, because it's because of her state. On our construction, she is within the scope of this policy, according to its rationale. Despite being within the scope of the policy, she's excluded from the benefits of the policy because of her immigration status.
Because if she, for example, qualified under the EU-SS scheme, in
Yes.
other words, if she had a different immigration status,
Yes,
you submit,
yes,
she would qualify.
yes, yes, and so that's
So you say it's direct discrimination, but you accept it's not on grounds of nationality, which is a suspect ground, whereas immigration status is not a suspect ground.
Yes, and thereafter, the core issue is that the is at paras 78 and forward.
Yeah.
So the core of it is that the decisions to make DDVC available to partners of TN workers and partners were measures of economic or social strategy of the kind recognized in Carson and Ba. And in my respectful submission, that comes off the right road, because it's identifying the creation of the EUSS scheme as the relevant decision. And so that would be fully accurate if the Secretary of State was identifying different categories and attaching a different consequence to each category. So if the Secretary of State was saying ab initio, this is a path that leads to settlement, this is not a path that leads to settlement, this is, that isn't. Those would be fully measures of economic or social strategy within the Carson and Ba parameters, or the social services or benefits cases. This is not because the domestic violence policy has an independent existence. It isn't simply an adjunct which, as a matter of discretion, the Secretary of State plugs classes into or does not. The case for the Secretary of State throughout has been that this is a discrete scheme, and this discrete scheme has a rationale, and that rationale is the one expressed by Mr. Wood and reflected by quotation in the cases, which has been adjusted post-AA, so to abandon the hard line drawn at settlement or British citizens. because of AA, it no longer has that fundamental silver delineation between those categories. The delineation now is the measure of reasonable expectation of living permanently. So you don't have to have indefinite leave. It's not enough to have limited leave, but limited leave qualifies if you have the reasonable expectation of staying.
Why isn't it a measure of social strategy?
It isn't a measure of social strategy because it's, in our case, because it's essentially an interpretation argument. We're within the policy. The policy applies to us. And the policy, this isn't a discretionary policy. The policy isn't worded to say, if you have a reasonable expectation of settling permanently, the Secretary of State can then decide whether or not to allow you to do so. That would be different. This is a policy that the Secretary of State says has a settled rationale that applies to everyone, and the filter is the rationale, not an executive decision. The Secretary of State could organise things in a different way, but that's the way it's organised at the moment, at the relevant time. So that is our case.
Would it be too simplistic to see it this way? That one of the, perhaps the significant consequence of qualifying under the concession is that you can, in principle, have access to public funds.
Yes.
Now, isn't the allocation of public funds a matter of economic policy for the government?
My answer respectfully would be yes, but that decision was made at the time when the rationale was chosen for the policy. That's to treat the policy as opening a discretion. So if you have a reasonable expectation of staying permanently, the Secretary of State can decide whether to allow you access to public funds or not. But that would be a differently formed policy. I mean, here we rely on the policy as it is described by Mr. Wood at, I think, para 27 of his statement, where...
So far what you've submitted, Mr. Frith, doesn't seem to turn on any analogy with the EUSS scheme, because I think the submissions you'll make would hold true, if they're correct, even if we'd never left the EU and we didn't have the EUSS. Is that right?
It turns on the finding of equivalence, of course, but the justification argument doesn't turn on the EUSS at all.
Yeah. That's what I thought, because I think what you're really submitting is that when correctly understood, the Secretary of State's own policy leads logically to the conclusion that this appellant should come within it.
Yes. And so there's no separate decision which has the margin of appreciation.
I see.
Our status should be determined by the policy the Secretary of State has set out via her official. And that's not what has been done because of essentially erroneous interpretation of the requirements of the rationale. But for us, this is a case essentially of the type Lord Reid contemplated in Crown SG, which you have, I won't take you to it if I may, but it's the core authorities tab 1 as being a case where the assessment of whether situations are similar is generally linked to the aims of the measure. So the aims of the measure determine the basis of equivalence. The correct basis on which to decide whether our situation is equivalent to the EU people or to the spouses of refugees with limited leave is the rationale espoused by Mr. Wood. And the basis for justification also depends on the policy, and the rationale for inclusion in the policy. So, on our ground, where at 81, Mr. Justice Carr said, nevertheless, the decision to create the EUSS and thereby the class of persons entitled to pre-settled status, able to sponsor family members to join them, was a measure of economic and social strategy, which flowed from, and we can agree entirely with para 81. We do. Well, I'm sorry, I'm not sure our agreement is irrelevant. But there's nothing in our case which is contra para 81. The difficulty applied to this case is that the Secretary of State didn't create the EUSS class and say, well, I'm going to attach a characteristic to that, like saying it leads to settlement. The Secretary of State says this is a class to which the rationale applies. But the dominant factor there is the rationale of the policy. It's not some independent judgment of the Secretary of State. The Secretary of State could have created the EUSS category as a distinct category with some sort of parallel scheme, rather than saying, these are people to whom I consider that the existing rationale, Mr. Wood's rationale, applies, but didn't. And so that's our case. Para 81 can be taken as entirely correct.
What about 82?
Para 82, the UK was entitled as a further measure to decide to extend the protections to bring the partners of those. Well, the point does not remove the fact that this is a freestanding policy, inclusion to which depends on application of its rationale. So the Secretary of State isn't saying, I'm going to attach a characteristic to this. I'm going to treat them as if the rationale of the DDVC applies. The Secretary of State is saying the rationale of the DDVC applies and doing it without changing the rationale of the DDVC.
Well, he characterised it as a further measure of economic and social strategy. Do you accept that?
Well, but we're not, that also isn't the decision that we're challenging. We're not challenging the inclusion of EUSS people. It's for the Secretary of State to decide whether the Secretary of State thinks that those EUSS people, their partners potentially come within the rationale of the policy.
What Mr. Justice Carr appears to be saying at the end of paragraph 82 is that the Secretary of State was, indeed the UK as a whole, was effectively treating those living here under the EUSS in the same way as a British citizen. And that may be where he finds the link with the underlying rationale of the concession, which is, as we've seen, subject to the refugee exception,
Yes,
necessitated by A,
yes,
but fundamentally, at root, the
Yeah.
original concession was based in people being either citizens or ordinarily resident.
yes. He doesn't elucidate it as such, or he doesn't elucidate it substantially as such. And our case would remain that the DDVC and the wider domestic violence policy is, as it were, its mechanism for inclusion is self-defining, and the Secretary of State doesn't change that.
But, Mr. Frick, you may be right. I'm not saying you are. You may be right about that, but I'm not sure that that's the analysis which has to take place under Article 14, because your case is based on Article 14, and it's therefore a case about, you say, unlawful discrimination. And the unlawful discrimination therefore requires at least a comparison with another group. Now, sometimes that can be a hypothetical comparator. I understand that. But here, at least as the judge seems to have understood the argument, the comparison being drawn for relevant purposes in this section of the judgment was with those who come under the EUSS. And the judge explains why there is an objective and reasonable basis for distinguishing between your client and someone who qualifies under the EUSS. So at least speaking of myself, I think you do need to attack his reasoning in saying that that distinction is objective and reasonable. Because simply to say that you qualify according to the rationale of the policy, you may be right, but I'm not sure that's an Article 14 argument.
Well, the Article 14 argument is, that there is discrimination in excluding is essentially that it's paradoxical to exclude us from the benefit of the DDVC when, according to DDVC's own rationale, we qualify. And there would be a question of justification if the DDVC had built in some form of discretion and some discretion were being exercised against us. But that's why this is essentially an interpretation challenge.
Right. Thank
And nothing in Article 14 requires that the decision we challenge be, as it were, a decision at one remove or two removes from the decision taken in respect of us. The Secretary of State created the EUSS category. That was a decision of social and economic policy. That didn't itself require them to have the benefit of DDVC. The Secretary of State decided that they had the benefit of DDVC. That would certainly have had social and economic consequences. But it's not the Secretary of State's case. The Secretary of State nowhere says, Mr. Wood nowhere says, that actually the rationale we have varied. So it's not the same rationale we're applying, but we're applying a different rationale, which is that there's some element of policy in who we add in here, rather than having a rubric, rather than having a rationale that determines who's in and who's out. And so we're really relying on Mr. Wood and the way the Secretary of State expresses this, which is consistent with the way the Secretary of State has expressed it all through the cases. So this isn't a discretionary adjunct where the decision to attach it to a particular category is a discrete decision. This is a policy which, as it were, determines inclusion or exclusion itself. And in his skeleton argument, my learned friend says, well, the Secretary of State would like to support victims of domestic violence, but it doesn't follow that being a victim of domestic violence should in itself be a reason why someone who came as the dependent of a person with LLR should be granted. We agree, but we again refer to the Secretary of State's own evidence as to the nature of this policy and its, as it were, self-determination of inclusion or exclusion via the rationale that Nick Wood described, which is reasonable expectation. The reason the tripwire is reasonable expectation of being able to stay is for the interest that follows in that text, which is that someone may have weakened ties based on the status they had. And so that's essentially standing up the rationale, and the core rationale is reasonable expectation of being able to stay. It's a straw man for the respondent skeleton to say we can't support everyone. What our case is, the respondent has a policy under which, correctly applying the rationale of that policy, we're included. And beyond that, we're not even saying you should apply that policy to any people who aren't included in the rationale, or to everyone with limited leave, or to all victims of domestic violence. The respondent skeleton also says it's an anomaly that those who have limited leave to remain have access. But that's a feature of the DDVC as now expressed. The DDVC was differently expressed before the decision in A. That caused the Secretary of State to re-express it, and the question now is who's within and who's without that re-expression. And our case is, our respectful case is, we're within it. And as we're within it, it's not a matter of there being a discretionary decision.
That we understand.
And on the respondent skeleton para 80, well, the judge was right to consider justification by reference to the EEA PSS cohort, because that was the sole cohort which is made to assume as analogous, and that's referring to the judge at 78. But his being prepared to assume that it was analogous at para 78 meant, well, the means by which analogy had to be gauged was whether the rationale applied. So the way to read para 78, if he was applying the rationale as the measure, and again, it's Lord Reed para 9 in SG, is whether is whether they're equal in terms of the rationale. And so that's my response to the respondent's point at para 80.
Yes.
I'm sorry, I've taken a few minutes extra. I'm very
Please
grateful
don't
for being
worry.
moved on, because that has helped me to focus on the core.
Mr. Fripp, please don't worry, because we've had some questions for you, and speaking for myself, it's been very helpful to hear how you put your case. Is there anything else that you would like to add in your oral submissions?
No, my lad. I mean, the respondent's application I can address as
Yes.
necessary in
Yes.
response.
Thank you
I'm
very much.
grateful.
May I just check if my lord has any question? My lady,
No, I'd just ask one, please.
please.
Mr. Fripp, I just want to be clear that I've understood your argument. Because I understand what you're saying about the policy. You're saying the Secretary of State's policy is not the published policy that we've looked at, but is paragraph 23 of Mr. Wood's witness statement. Is that the argument?
My lady, yes, against the background
Right.
where,
Sorry, can I just get a note?
in fact, I'd be happy to say yes, full stop. But
Right.
yes, with Laureley qualification, yes. I mean, the 2018 written DDVC policy, it's no one's case that literally reflects the law.
No, I understand the qualifications about refugee status and so on, but leaving that at one side, as I understand your submissions, that is your case.
It is, yes.
Yeah,
It's
okay.
it's
It's very helpful.
Thank you very much. Yes, Mr. Anderson.
Thank you, my lords, my lady. What I propose to do is to go through the development of the policy, which I think I can take reasonably quickly in view of you having been taken through much of it by my learned friend, and then that will probably take me up until lunchtime, and then move on to consider the appellant's grounds and the Secretary of State's application in relation to the further evidence as to the status of her husband.
Mr. Anderson, I know that you will bear in mind that to some extent, at the court's suggestion, Mr. Fripp curtailed some of his submissions because we felt that they might perhaps better be taken in reply. That does have the consequence, and I know you'll bear this in mind, that you must leave plenty of time for him to reply fully to what you say. Thank you.
Thank you, my Lord. Well, my Lord, first of all, just in terms of the framework against which the court needs to be assessing things, as my learned friend said at the outset of his submissions, we're agreed that the questions that had to be asked in this case are the questions set out in Parkin and Secretary of State for Work and Pensions. We're agreed that the circumstances fall within the ambit of a conventional right. We're agreed that the claimant has a status for the purposes of Article 14, that status being immigration status. We're agreed that there is a difference in treatment between the claimant and another person, though we need to be clear as to what other person it is we are talking about. There is disagreement as to whether or not the claimant's situation is in relevant respects analogous to a relevant comparator. It is agreed that in any event the treatment is on the grounds of the claimant's immigration status, and for the avoidance of doubt, in domestic law terms, one could characterise that therefore as direct discrimination. It's not an indirect discrimination case, although for reasons I'll go on to submit in my submission that isn't particularly material when it comes to considering justification in this context. And then the final question is the treatment justified, from which of course we take issue and to which the appellant's grounds of appeal are directed. Against that background, in terms of the questions that ultimately needs to be asked, I think before I go through the development of the policy, it's worth recalling that in terms of Mr. Justice Carr's judgment, he rejected the appellant's submission that she was in an analogous position to the spouse or partner of a person present or settled in the UK. And in my submission, it's clear that that was a finding that the judge made, and it's not a finding that is challenged in the grounds of appeal. And he also rejected the submission that the appellant was in an analogous position with regards to refugee status. And just so that you've got those references, they're in the core bundle at page 107, at paragraph 66, where midway down the paragraph he says, taking first the analogy with a British citizen or settled person, in my judgment their respective stations are not similar at all. Tier 2 migrant workers on a path that leads to settlement but not as good as settled already. Obstacles may lie on the path. And then at paragraphs 67 to 69, over the page 108, he addressed the analogy between a Tier 2 worker and a refugee, and again concluded that there was no analogy. And again, there is no challenge to the judge's conclusions in that regard in the appeal. But what he did go on to do at paragraph 73, he said that applying a reasonably broad brush without the aid of statistics or minute and detailed comparison, and prepared to assume that there is a sufficiently close analogy between the Tier 2 worker and the EEA national pre-settled status, so that, answering the second part of Justice Lang's third question, I assume their situations are, in relevant respects, analogous. And so that was the only of the putative comparators put forward that the judge considered might properly amount to a comparator for the purposes of the Article 14 analysis. As we noted in an earlier exchange, it's expressed as an assumption rather than a finding, but in any event, the Secretary of State has submitted a respondent's notice in order to argue that the judge would be wrong to, the court would be wrong to proceed on that assumption, or in any event would be wrong to proceed on that basis.
Can I just ask you about that approach? And again, please don't take anything out of order, but just so that you're aware of what the court is interested in. Speaking for myself, and I think this reflects the approach of the Strasbourg court and what many judges in this country have said, most notably Lord Reed in SC. Often, the question of whether two situations are analogous and the question whether there is objective and reasonable justification for the distinction, as one of the cases put it, cover the same ground.
Yes.
And I'm not sure that in all cases, or perhaps even in many cases, it's actually helpful to draw a rigid distinction between the two. But I mention that to you because the respondent has filed the respondent's notice, but I thought you should have the opportunity to deal with that point. I'm not sure myself that actually it's a particularly helpful way of looking at questions under Article 14, and particularly in this kind of context where actually the answer to both questions may turn on the same matters.
I mean, my lord, I entirely accept that they're not hermetically sealed as aspects of the analysis. There will be some cases in which it may more obviously or more conveniently be dealt with by saying two people just aren't in the same position at all. There are some where it will be more conveniently dealt with by saying, well, they're in a similar position, but there are these differences, and those differences explain why the difference in treatment is justified. I fully accept that those are not necessarily or don't always need to be separated as parts of the analysis, and that an unduly rigid approach shouldn't be taken. But nonetheless, it is important in my submission when considering the issue of justification in this case, one does it against the background of the court below, that is, unchallenged reasoning in connection with the differences between a person who is a Tier 2 migrant and a person who's settled or a person with refugee status, and why that meant that in the view of the judge below, you didn't even need to get to the justification analysis.
Oh, that I fully understand. It was only that the respondent's notice specifically challenges what the judge said at paragraph 73 and 74. And there are 2 points about that. One, on the face of it, it doesn't appear that he actually made any decision at all. He merely made an assumption, and you've dealt with that. The second point is that, at least speaking for myself, I'm not sure that it is necessarily helpful in answering this question. The crucial question may be one of justification, but actually once you've answered the justification question, that may then in fact lead you to say the two situations are not analogous.
Yes, my lord, yes. I'm grateful for that indication, but that is, I certainly agree that they're not necessarily disparate categories, and there's no necessary requirement that you address them in a sort of particular order. Sometimes it will be more a case of finding the appropriate expression for the conclusion that's reached at the end of the analysis and which of those headings it falls.
Thank you.
So turning then, though, just to the development of the concession and of policy with regards to indefinite leave to remain for victims of domestic violence. This is covered both in the judgment from paragraph 7 onwards and also in the statement of Nick Wood. And as my learned friend noted, the policy originated in relation to victims of domestic violence as a concession outside of the immigration rules. In relation to victims of domestic violence with limited leave to remain as the spouse or partner of a person settled in the UK or a British citizen in circumstances where the relationship had broken down due to domestic violence. And the fact that it was a grant of indefinite leave to remain mirrored the fact that the leave of the partner being relied upon was a form of indefinite leave to remain in the had settled status rather than limited leave. And it was a key feature, as it were, that there was a bright line rule there that the partner be a citizen or settled. And the rationale is explained in paragraphs 5 to 6 of Nick Wood's statement, which you were taken to earlier, effectively, that it would be reasonable to expect that somebody coming to the UK, on the basis that they're going to be living with a permanently settled partner, may loosen or cut their ties with their country of origin, and they shouldn't feel compelled to leave when the reason for their having come falls away as a consequence of domestic violence. And he contrasted that with the position of a person coming on a temporary basis who doesn't have any guarantee of being in a position to apply for indefinite leave to remain.
I'm not sure it, in substance, is saying anything different, but can I just put to you the way I think I was trying to put it in F.A. Sudan, that otherwise there's a risk that the immigration system itself will contribute to an injustice, which is that the reason why the abused partner is reluctant to leave the situation in which they are being abused is because of immigration.
Yes.
But if there are other reasons, because, for example, they didn't have a reasonable expectation of permanently settling in this country, then I think you would submit that fundamental risk of injustice flowing from the immigration system itself doesn't actually arise. Obviously, no one is suggesting that domestic abuse is anything other than a great social evil.
No.
But I think you would go on to say, well, there are other ways in which the state tries to deal with that evil. I mentioned in F.A. Sudan that there are policies like, well, there's the criminal law,
yes.
First of all. There can be other kinds of funding arrangement, for example, for domestic refugees and things of that sort. But what I think you're saying is that in this context, what we have to focus on is that fundamental rationale that because of the way in which the immigration system is structured, somebody may in fact not leave the abusive situation.
Yeah.
Is that right?
I think my lord, yes, I think that's a fair summary of the situation. And that policy was then formalised originally in Rule 289A and then in Appendix FM. But a difficulty was found to arise, which was that individuals eligible to apply for indefinite leave to remain under the policy may not be able to leave their spouse in order to do so, because as part of the conditions of their limited leave would be a no recourse to public funds condition. So initially that was addressed through a project of effectively providing funding for various refugees and such, and then a concession was created which effectively provides for the grant of limited leave for a period of 3 months without a no recourse to public funds condition, so that somebody can then access a refuge or alternative support in the same way as they would be able to if they had access to public funds. And that was recognised, again, by Lord Justice Moore-Bick in T and in Lordship's judgment in FA. That's a very limited purpose that the DDVC itself has. So, just pausing there, and if one's looking at things simply through the lens of that original policy, aim and scope, there was a clear distinction drawn between partners of those, somebody settled or British citizen, and those with other statuses in the form of limited leave, and applying the judge's analysis below, at that point there wouldn't have been any comparator that the appellant could pray in aid that would even take her to the stage of justification for the purposes of an Article 14 claim. The line was very clear, the reason very obvious in terms of the different positions of those two groups. You then have the decision of the Court of Session in A, which you've already been taken to, And so I think I can take this quite brief. There are a couple of points I'd like to highlight. You were taken to paragraph 66 which is in the supplementary authorities bundle. Sorry, in the.
It might be the first one.
It's in the core authorities bundle.
Yeah.
Sorry. Tab 2. And Lady Dorian here in her judgment essentially draws two poles in a sense. On the one hand, you have persons who are the spouse or partner of a British citizen or somebody settled. On the other hand, you have persons like workers and students. And then the question was, in a sense, well, where do refugees fit between these two poles? Now, just in terms of how that analysis was structured, I certainly don't think it can be said that in referring to workers, Lady Dorian had specifically in mind any particular subset of workers, for example, ICT transfers or seasonal workers or anything like that. I think it was just being used in the general sense of persons who are coming to the UK to work. And one of the contrasts she drew, as your Lordship noted earlier, was the contrast between the fact that a worker or student comes to the UK out of choice rather than out of necessity. But just to point out the other contrast that she draws is in relation to the extent to which the status of somebody with refugee status is precarious or not. As she notes about a third of the way down that passage.
Sorry, which passage?
In paragraph 66.
Thank you very much.
A person, it's about 9 lines down, a person admitted to the country as a student or for work is very clearly someone admitted on a limited and temporary basis, entirely at the discretion of the state. The status of refugee, as has been pointed out, is declaratory. Once it's been determined to exist, the state has no discretion in terms of its international humanitarian obligations, but must grant asylum. The worker or student enters the country by choice, the refugee out of necessity. And she then goes on to say the circumstances in which refugee status may be lost are extremely limited and can in no reasonable way be compared to the situation applying to a worker or student. Once refugee status is acknowledged, international obligations require the state to facilitate assimilation and naturalization. Again, a situation quite different from that of a worker or student. And then she says that we accept it's not reasonable for the spouses of students or workers to have any reasonable expectation of having their future and a permanent home in the United Kingdom, and that such spouses are less likely to cut or loosen their ties with their country of origin than the spouses of British citizens or persons with settled status. We cannot accept that this applies to equally to the spouses of.
Can we just unpack one phrase that Lady Dorian used there, just to be clear in my mind? When she said the status of refugee is declaratory, do you accept that it therefore is retrospective? In other words, that the person, it's not that it declares what the situation now is and for the future. It's recognising that they are a refugee. I think that may be relevant to how she then goes on to reason how they're more analogous to the person who comes for settlement purposes. Because then you can understand that there would be, from the outset, as she said, it would be fanciful to suppose that they wouldn't loosen or cut their ties with their country of origin.
My lord, I haver a little because the question whether the status is the declaration of somebody, it isn't necessarily retrospective.
Right.
Because in principle you could have somebody who acquires their refugee status as a consequence of events after.
Well, certainly, I mean, you do get that sometimes when there's been a coup d'etat in their home state while they've been here as a student.
Yes.
No, I fully accept that. All I was trying to unpack was that there's some significance in the point that she says it's declaratory. In other words, it's recognising a status. It's not creating a status.
Yes.
Doesn't flow from the declaration.
Mm.
Yes, that's right. Yes.
Yeah.
That's certainly right.
That's all.
And so there are a number of differences that she identifies that lead her to conclude that refugees come, as it were, closer to the settled, or are close to the settled pole and not analogous to the worker or student pole, which is then reinforced by the statistical information that she refers to at paragraph 67. And then the other feature of the judgment, just briefly to touch on, are the points made at paragraphs 79 to 80. And this is in relation to the question whether there had been any consideration of the position of refugees as such. And just to be clear, the background to this element of the judgment is the fact that at the time the concession in relation to victims of domestic violence had been introduced, the general policy was that refugees were granted indefinite leave to remain from the outset. So they didn't have a period of limited leave to remain.
And as I understand it, that changed in 2005.
Yes. And there was no consideration, and so that's why the court says that there had never really been any consideration of what do we do about refugees with limited leave to remain, because that category simply didn't exist when the domestic violence concession was introduced, which is obviously, in my submission, not true of the category of persons granted limited leave for reasons of work or study. And so there isn't any similar point that could be made in the context of this case. So, following that decision, the Secretary of State has then amended the domestic violence concession in the immigration rules with regards to indefinite leave to remain. She hasn't yet updated the DDVC policy itself, although my instructions are that there is currently work being done to publish revised guidance in view of the decision in AM, and there'll be a suite of guidance documents accompanying that, which also, just briefly, can answer the question whether there's an appeal against the decision in AM. There is no appeal against that decision. The Secretary of State is amending her policy in light of it. But again, just turning to the way that the...
Sorry to interrupt. So is the policy at the same time going to be updated to reflect the decision in the Scottish case or not?
My understanding is that there will be a revised DDVC published in conjunction with the revision of the... so the AM decision requires a change to the indefinite leave to remain policy itself, but I'm instructed that accompanying the changes to that policy will also be changes to the DDVC and related documents.
And presumably to reflect the EUSS exception now as well.
One would think that would certainly be sensible. I don't have specific instruction on it.
I understand, yes. Well, that's very, speaking for myself, I find that very helpful, Mr. Anderson. We shall have to give consideration to what we might say in any judgment. Whatever the outcome of this appeal is, we may say something about the desirability of there being revised guidance, so that everyone concerned, including the case officers, actually know exactly what the correct policy is that they should be applying.
But sorry, no doubt it's my fault, Mr. Anderson. I understand what you're saying about the decision of Mrs. Justice leaving in AM, but is it proposed to update the guidance to reflect the Scottish decision in A?
So I will perhaps just see if I can take a further instruction this over. Right. My understanding is that the intention is to provide
a
fully update the and any update should obviously
right. Okay. Well, I think
that's how I understood you.
Yes. Yeah. Well, I wasn't clear, so that's why I asked the question again. But if you could take instructions on that point, that'd be very helpful.
Right. Thank you. Would that be a convenient moment?
My lord, yes.
So we will resume at 2 o'clock.
All right.